and it was immediately sealed off. But it is relatively under control, but not totally. And
yeah, because I have some friends in Germany, and there were, for example, we have one of our professors in Germany right now in Munich, and she told me that there things are a bit normal, but people are still maintaining social distancing and everything, but not fully 100%.
So one has to be very cautious and very careful, in particular in the public. No doubt about it. So we are proceeding in the moment with our lectures in Germany. We have here what we call the summer semester, and we're doing it here at Heidelberg University by these systems, not by Zoom. We were advised not to use Zoom because of the so-called Zoom bombing. But we have internal, very well working internal systems. The German research network, and we have also a very specific system here at our university. So I give my lectures always in this specific German network system, which is interactive. And I can see at least about 20-25 of the students, and I can pose questions to them, and they can ask. And they can answer. So it is not asynchronic, but it is synchronized. This works pretty well, but of course it cannot substitute the living atmosphere and the inspiring atmosphere of a lecture hall. When you have the contact, you see the eyes of your students, and you immediately recognize if these eyes becomes a bit tired, that might be you haven't explained something very well. It is a stiff atmosphere. It is, no doubt. And the students cannot see each other in the system. I can see them, they can see me, I can ask them, right? But they hear each other. They hear each other. But it's a pretty safe system, and so we were advised here by our university administration to use safe systems.
Yeah, just to let you know, we didn't have any Zoom bombings or nothing of the sort here.
Okay.
No worries about that.
No, everybody, we are live on YouTube now, just warning you.
No, we don't have not Republican discussions here.
Whatever you speak is fine for the public.
Yeah.
And I think we can start it formally. Fernanda, fique à vontade. Feel free to start when you want.
Oh, thank you. Muito boa tarde. É com muita alegria, muita honra que a gente oficialmente, então, faz uma abertura de uma live tão importante como esta, histórica para a Universidade de Marília, como sempre a nossa querida professora Mariana costuma dizer, e essa realmente fica para a história do programa de pós-graduação, mestrado e doutorado em Direito, mas não apenas para o programa, mas sim para a universidade. Hoje nós temos a honra de receber em nossa instituição o nosso querido professor Muller-Graff. Realmente é uma honra, professor, tê-lo em nossa instituição. Eu costumo dizer que mesmo virtualmente estamos muito próximos, como se lado a lado estivéssemos. Então, não posso aqui deixar de fazer meus cumprimentos especiais à vossa pessoa, mas principalmente pelo que o senhor representa para a academia. Então, portanto, meu muito obrigada mesmo por aceitar esse convite. Agradeço e, novamente, cumprimento o nosso coordenador do programa de pós-graduação, professor Jonathan, A gente tem estado muito próximo esses dias, quase que diuturnamente estamos juntos. Eu tenho falado que estamos numa maratona de lives, realmente de trabalho árduo, mas especialmente eu preciso aqui novamente agradecer e dizer desse novo modelo de ensinar, de aprender que o professor Jonathan e sua equipe da pós-graduação têm mostrado para o mundo. Digo isso porque hoje nós abrimos as portas da Universidade de Marília para o mundo. Que alegria, professor Jonathan, poder, de fato, estar contigo numa live tão importante como esta. Também quero cumprimentar e agradecer muitíssimo minha amiga. Tenho certeza que foi pela nossa amizade que a professora Mariana me convidou para estar aqui. Meu muito obrigada, professora Mariana. A professora Mariana é nossa inspiração dentro da Academia Feminina da Universidade de Marília. Ela que realmente tem transformado a realidade realmente, né? E aí a professora Sinara, que eu também aproveito para cumprimentar, a professora Sinara vai poder validar tudo isso que eu disse, porque a professora Sinara foi orientanda da professora Mariana, e então pôde acompanhar bem de perto tudo isso que Mariana representa, não apenas no corpo docente da Universidade de Marília, mas discente também. Quero também cumprimentar os professores que compõem essa importante banca aqui, né? Nós estamos entre amigos nessa live, como diz a Mariana, é para ser uma live mais sem tanta densidade, porque realmente o mundo lá fora não está dos melhores. O professor Miller também dizia isso não é no Brasil, nós estamos vivendo uma pandemia, né? Então, realmente, esse é um cenário mundial. Dizer, professor Rogério, da minha alegria de estar aqui contigo, e também, professor Marcelo, uma honra poder, assim, viver essas horinhas, né, que passaremos juntos. Portanto, muito obrigada. E aí eu volto a palavra para a professora Mariana, ela que está conduzindo. Digo, viu, professor Marcelo, que os nossos professores, a Universidade de Marília, está com muito receio de perder os docentes, perder o professor Jonathan, professor Rogério, professora Mariana, para os youtubers, porque estão verdadeiros youtubers aqui faz like, sininho. Então a gente está preocupado, acho que a profissão de professor tende a virar youtuber daqui uns anos, viu, professor? Muito obrigada, Mariana, está com a palavra. Obrigada.
Obrigada, Fernanda, pelas suas palavras, lindas palavras, humanas palavras, assim como a pessoa que você é. Eu peço licença agora para os nossos alunos para começar a falar inglês, para deixar o nosso palestrante se sentindo um pouco melhor, um pouco mais em casa. Ok? E aí, não entre em pânico. Se eu perceber pânico, eu volto um pouco para o português, tá bom? Good afternoon, my dear students, ladies and gentlemen. For those who don't know me yet, my name is Mariana Santiago. I am professor of the master's degree and doctorate in law at the University of Marília. I hope you all are well and safe in these difficult times that we are living now. We will start now our weekly event titled Dialogues on Development, Company and Society. It's an event organized by University of Marília, but it's now completely open to all law community. So welcome everybody. It's a pleasure today to have with us Herr Professor Dr. Peter Christian Muller-Graff from Universität Heidelberg in Germany, one of the most famous universities in the world. Professor Muller-Graff, he has published many books and articles, including in Argumentum Journal of Law from this university. He has been judged at the Court of Appeals in Germany, and he also has received many prizes, including doctorates honoris causa. He has also accepted several visiting scholarships in many countries like France, Belgium, Austria, Switzerland, Poland, Hungary, United States, Brazil, and Japan. It is a great honor for us to welcome you, my dear professor. Willkommen. Today, his lecture will be about fundamental rights in the European Union Federal Community Law. I would like to mention the presence here today of Professor Jonathan Vita. He is the coordinator of the Master's and Doctorate in Law at the University of Marília. And Professor, my dear colleague, Professor Dr. Rogério Molica from the University of Marília. And the very, very special presence of Professor Marcelo Figueiredo, one of the most important constitutional law professors in Brazil from Catholic University of São Paulo. They all will discuss the topic with us in a dialogue. This is the idea of this event. So finally, I wish everyone a great experience. I'm very, very happy with this event today. Professor Muller-Graff, feel free to start the lecture when you want. You know, my German is terrible, but today I want to try some words for you. Please don't kill me. I hope we stay friends after this. Es ist uns eine große Freude, Sie bei uns an der Universität Marília begrüßen zu dürfen. Vielen Dank.
Spectabilis Fernanda Serva, caro colega Ribeiro Santiago, queridos colegas, señoras y señores en todo el Brasil. Saúdo calorosamente do meu instituto na Universidade de Heidelberg. Vou lhe dar como pergunta qual é o papel dos direitos fundamentais na comunidade jurídica federal da União Europeia. Mas meu brasileiro não é bom, é suficiente. Por isso, vou falar inglês. Desculpe. The role of fundamental rights in the EU Federal Community of Law alludes first to fundamental rights, and second, to the idea of a federal community of law. Fundamental rights such as, for example, the rights to life and liberty, or the freedoms of expression, religion, and sciences, are collective promises of protection in a polity to any individual concerned. Which right is understood to be fundamental can vary between polities. So can the intensity of protection. For example, the respect for human dignity in relation to certain virtual killing games as a public physical laser sport, allowed in the United Kingdom, but prohibited in Germany. Or the protection of the right in one's own picture, such as the children of Princess Caroline of Monaco, in a conflict to the freedom of the press. Temporarily lower protection in Germany than under the European Convention for the Protection of Human Rights. Though this can vary. In a federal community of law, different promises can compete. Now, the question of the role of fundamental rights in the European Union's community of law cannot be appropriately addressed without first considering whether the category of federalism is adequate for the law of the European Union. Hence, my following observations are divided into two parts. First, the shorter part, very short part, whether this comparative category of a federal community of law is fitting the European Union at all. And then second, the longer part, which profiling characteristics of the protection of fundamental rights in the Union have to be discussed from such a comparative view. You can see already now that I'm going to answer the first question with yes, otherwise I wouldn't come to the second question with the different aspects. But it needs some reasoning why this is a proper approach. So first, the suitability of the comparative category of a federal community of law. Using this comparative category evokes the question of whether it is proper or perhaps misleading to use the word federal for the European Union in this specific context. Evidently, the European Union is not a state. Now, one must tread with caution. It is difficult to even bring up the question of using the term federal in regards to the Union, even if only in an adjectival way, without being immediately torn apart by the gatekeepers of the holy grail of sovereign statehood. There is a discussion. This hostility is attributed to one's interpretation of the term federalism. If federalism is understood in the sense of a federal state, its marriage with the Union is immediately hit by the carnassial teeth of Georg Jelinek, a former Heidelberg professor's globally well-known three-element dogmatic of statehood. You all may remember the three criteria: territory, people, sovereign power. It is beyond serious doubt that in nearly 7 decades of supranational European integration, nothing has fundamentally changed in the central aspect that each member state holds monopoly over legitimate physical power in its autonomously controlled territory and autonomously defines the criteria of citizenship. Hence, it did not come as a surprise that the Federal Constitutional Court of Germany, I'm going to abbreviate this court later on as FCC, Federal FC, Constitutional C Court. So it didn't come as a surprise that the Federal Constitutional Court of Germany, in its judgment on the constitutional compatibility of the Lisbon Treaty in 2009, it's now 11 years ago, also drew exactly this conclusion. Conversely, nothing has changed in this respect in view of the Union. The Union does not dispose of the means of physical enforcement against reluctant natural or legal persons, nor is it entitled autonomously define its territorial configuration, the criteria for Union citizenship, or its own competences. So far, so good. However, if the term federalism is separated from its state connection as a fundamental source of legitimation of collective sovereignty, and is related instead in a functional way only to the coexistence of public power of different public agents in the same territory, as one model of the territorial partition of power, then parallel questions, also not similar answers, but parallel questions emerge regarding the order and relationship of these powers in a federal state, such as Brazil or Germany on the one side, and the European Union on the other side. These questions can be called functional federal matters. For example, the questions of the partition and character of competences in relation between the regional and the federal polity, such as exclusive competences or shared competences, or the relation between conflicting provisions of the regional legislator and the central legislator, or the issue of mutual loyalty between the regional authorities and the central authority. Since the Union is doubtlessly a community of law, as described by the very first president of the Commission of the European Economic Community, Walter Hallstein, by the way, a former professor for private law and economic law, a community based on law, namely the treaties between the member states, and a community acting in the forms of law, namely in legally prescribed procedures and with legally defined instruments such as regulations, directives, and decisions. Since this character is again and again emphasized by the Court of Justice of the European Union, abbreviated ECJ, it is reasonable to summarize the totality of answers of Union law to such parallel questions as a federal community of law, a federal community of law, not a central community, but a federal. So far for the first part. This was the short part. And now we are heading into digging into several questions. The profiling characteristics of the fundamental rights in the European Union in a comparative federal view. On the one side, federal states, on the other side, the European Union. Moving on now to this second question, particularly in comparison of the European Union with, you may allow, federal polities in European countries such as Germany, Austria, Switzerland, Belgium. At least 8, now don't be terrified, but 8 criteria deserve attention. 8. Which 8 abstract aspects, before concretely treating them in a civilized time way, one after the other. First, the living federal promise of fundamental rights. Second, the federal architecture of the sources of fundamental rights and in relation to the Union specifically. Third, the federal scope of applicability. Fourth, their direct applicability and character as subjective rights in any national court. Fifth, their relation to national fundamental rights. Sixth, their judicial enforceability. Seventh, their scope of control relevance. And eighth, their potential for judicial references and political guidelines. Now, this is a huge program. I'm aware of that, and I don't want to extend it beyond a civilized time frame. So let's start first with the living federal promise of law in the Union. A federal community of law is not feasible without being founded upon the basis of a living mutual promise. The form of such a promise can vary. For example, Swiss citizens transmit from generation to generation the so-called Rüttli oath, if it happened, named after a geographical location, allegedly sworn by their forefathers on a meadow of the Alps, the Rüttli meadow, in the 14th century. In their native German, I just say now 2 sentences in Germany, but I translate it immediately into English. Wir wollen sein ein einig Volk von Brüdern. In keiner Not uns trennen und Gefahr. Wir wollen frei sein, wie die Väter waren. And so on. In English, we want to be a single people of brethren, never to part in danger nor distress. We want to be free as our fathers were, and so on. Now, this is the Rüttli oath in Switzerland. German citizens after being liberated from a most dire dictatorship in the last century, trust, in principle, in the federal basic law, as conceived by the so-called Herrenchiemsee Convention, named after an island in a lake in Bavaria where these people met, on an island in a Bavarian lake. Not in a lake, but an island. Yes, it is in the lake, but they did not meet in the lake, but they met on the island. And developed by the Parliamentary Council in 1948 and 1949, and which starts with the inviolability of human dignity and a catalogue of basic rights. The specific profile of the promise of the European Union and its community of law is established in the treaties between the member states, which express the Union's aim to promote peace, its values, and the well-being of its peoples. This is Article 3, Paragraph 1 of the Treaty on European Union, and which guarantee in particular the individual, now this is interesting because it is a bedrock, the individual transnational market freedoms as a prime vehicle of creating transnational contacts, networks, and thereby fostering a transnational polity and society based on shared values. And as a specific aspect of fundamental rights, the mutual promises laid down in the Union Treaty's article on values, which binds the Union and its member states to the values of respect for human dignity, freedom, democracy, equality, the rule of law, and the respect for human rights. This is a rather highly abstract oath, with the article leaving open how it is implemented. For the Union, and in a limited way for the member states, the promise of respecting fundamental rights is entrusted by a specific article, it's Article 6, Treaty on European Union, to two sources. First, the Charter of Fundamental Rights of the European Union. You can abbreviate it CFR. And second, the fundamental rights is general principles of the Union's law as derived from the European Convention for the Protection of Human Rights and Fundamental Freedoms. This is not to be mixed with the Charter of the European Union, because this convention is a totally different international convention, and also as derived from the constitutional traditions common to the member states. So far, we see a parallel of the living mutual promise of law in states and the European Union. This was already the first aspect. Second aspect, the federal multipolarity of sources of fundamental rights in the European Union. The federal architecture of sources of fundamental rights in the Union is multipolar. Often called a multi-level system, this widely used wording should not evoke, level. When you think about a level, there is an upper level, a middle level, a lower level. This widely used wording should not evoke the idea of a simple hierarchy, which in reality does not match the normative complexity of this whole normative system. Rather, I'm talking about a multipolar system or a cosmos. Normative declarations of fundamental rights exist at many points in the federal legal cosmos of the Union, wherever. For example, in subnational constitutions of federal states, for example, in Bavaria, in Germany, or in the state of Vorarlberg in Austria. They exist in national constitutions of the member states, for example, in France, Portugal, Ireland, Finland, Poland, Italy, or Greece. They exist in the codified primary law of the European Union. I'm going to elaborate this later on. And they are also found in the invisible energy of the just mentioned general principles of Union law. By the way of the latter, the so-called general principles, ideas that have been developed in other normative universes can serve as sources of inspiration, persuasive authorities, and fortifiers of convincing authority for the development of protection under union law. Those other normative universes are in particular international conventions or texts, such as the just mentioned European Convention on Human Rights, the European Charter of Social Rights, or the United Nations Declaration of Human Rights. But they can also be found in national legal orders from both within and outside the Union. Against the background of the global spread of normative ideas and of the emergence of transnational common legal thinking, exactly what we are doing in the moment, this multipolar situation offers fertile ground for the solution of concrete conflicts and even for inspiring thought about the abstract formulation of codified texts for the protection of fundamental rights. One example, the inclusion of the principle of environmental protection connected to the so-called third generation of human rights, which was not developed in a legal system of a European state, into the Charter of the European Union. This multipolarity of sources of fundamental rights in a federal community law is not particular to the Union. Again, we find a parallel to federal states. In addition to the example of Germany and Austria already discussed, the same is true for Switzerland. For example, the constitutions of the Canton of Zurich and the Confederatio Helvetica. This is Latin, and since your native language is Portuguese, I don't have to translate a Latin word into a Portuguese word. Or the United States. For example, the Constitution of Massachusetts, and on the other side, the Federal Bill of Rights. While, for example, Article 1 of the Constitution of Rio Grande do Sul refers in this respect to Chapter 1 of the Constitution of the Federal Republic of Brazil, dos direitos e deveres individuais e coletivos. But the specific distinctive characteristics of the role of the fundamental rights of the Union become apparent when comparing them in the light of some of the other mentioned criteria. And if you have counted, we have treated now 2, so there 6 are left to be looked upon. And first of all, the light of the federal scope of applicability. This is, in this structure, now the third aspect, the federal scope of applicability of the Union's Charter. When using the German Federal Republic's constitution, the basic law, also called Grundgesetz, or the Brazilian constitution, as a standard for assessing the federal scope of applicability, a very first distinctive feature of fundamental rights in Union law becomes apparent. Article 1, paragraph 3 of the basic law, Grundgesetz, is worded in translation: the following basic rights shall bind the legislator, the executive, and the judiciary as directly applicable law. This applies, this very short sentence, very simple sentence, applies to all levels of public authorities within the federation. The federation itself, the states, which are called Länder in German, the local communities, and all other public agents. Such a federal claim of universal applicability to all acts of all public authorities within the relevant territory is not inherent in the Union's Charter. And here the problems start. Its scope of applicability is restricted by its Article 51, paragraph 1. It says that, I quote, the provisions of this Charter are addressed to the institutions, bodies, offices, and agencies of the Union, and the member states only when they are implementing union law, unquote. Now, you're aware the accent is only when implementing union law. Now, the legal conundrum is incorporated in this wording, only when implementing. A long-standing dispute exists over the question whether the term implementing adopts the narrow implementation formula of a former judgment of the European Court of Justice from a time in which this charter did not yet exist, because it came into force only with the Treaty of Lisbon on December 1st, 2009. But already before, we had questions of the protection of fundamental rights under former community law. And here it was the Court of Justice, the European Court of Justice, which was asked and had to give rulings. Now, here a dispute exists. Why? Because there are two lines, two strengths of jurisprudence of the European Court of Justice. One case is called the case Wachauf, 1989, which addresses only the application of the union's regulations. You can say the European statutes by national authorities, and only addresses the application of the union's regulations by national authorities and the transposition of so-called directives into national law. This is Wachauf, 1989. Or with a specific article of the Charter, this is Article 52, paragraph 7, activates a larger formula of another former judgment of the European Court of Justice of 1991, 2 years later. This is the case ERT, Ellenika Radio Television, comes from Greece, which reads, they are applicable, at that time, the unwritten fundamental freedoms are applicable to any national measure falling within the scope of community law. Implementing on one side, falling into the scope of community law on the other side. This latter formula also comprises national measures which are not implementing union law as described, but are taken in areas covered by union law, such as, for example, trade restrictions between member states, national trade restriction of member states, such as, for example, the restriction of imports adopted by a member state, this was Austria, of journals which contain promotional games, thereby creating a conflict not only between the national objective of combating addiction to gaming and the free trade of goods, but also freedom of the press. So it becomes more complicated. Now, a new formula, which the European Court of Justice created in a decision of 2013, this is a case coming from Sweden, Åkerberg, Fransson, has evoked concerns over whether the European Court of Justice is beginning to transgress the limits intended by the member states when they agreed on the term implementing, in the German version durchführen, and expressly laid down, I quote, the Charter does not extend the field of application of union law beyond the powers of the Union or establish any new power or task for the Union or modify powers and tasks as defined in the treaties, unquote. Now, this Åkerberg formula stipulates that the Charter is applicable, I quote, in all situations governed by European law. You know, words matter in statutes and in judgments. Though we are not talking about implementing, not falling, talking about falling within the scope. Well, this was ERT. But now we are talking about the word in all situations governed by European law, unquote, and hence applicable for, quote, national legislation, which are falls within the scope of European Union law, unquote. Now, this formula evidently resembles the broader ERT formula and could indeed open the way for encroaching upon the use of competences of the member states. Now, since the ratified words of the member states enjoy prime legitimate authority, the European Court of Justice is, in my opinion, well advised to take a cautious approach in applying its governed formula to concrete national measures beyond the two mentioned older decisions. ERT is, in my opinion, incorporated because of a wording also found in the Charter. This is Article 52, paragraph 7, I quote, "The explanations drawn up as a way of providing guidance in the interpretation of this Charter shall be given due regard by the courts of the Union and of the member states." Okay, this is then not only Wachauf 1989, but also ERT 1991. So far, this aspect, independently from drawing this borderline in a concrete case properly of the applicability of the Charter to a national measure, it must be stated for the comparison of federal communities of law that the Charter does not address national measures that are not implementing in the sense of Article 51. There is a borderline. You can have disputes over where exactly this borderline runs, but there is a borderline. For example, rules on national general election laws or the organization of the national administration. Here it would be clear, no falling within and no implementing in principle. Hence, the first distinctive feature of the Charter is its restricted federal scope of applicability. Very different from the German situation, and as I understand also from the Brazilian situation, but there you might correct me, this is only the thesis. This brings me to the already fourth aspect, the direct applicability and subjective rights. In respect to direct applicability, which means that any national court confronted with such a question has to apply a fundamental right and gives to an individual concerned a subjective right. Now, in respect to direct applicability and subjective rights, which can be evoked by any individual or in case by legal persons before any court, the basic law standard is clear. It rejects all theories held, for example, under the former Constitution of Weimar, 1919, already 100 years ago, which consider fundamental rights only as programs for political action. Not a subjective right, but only a program for political action. But not as a subjective right. This is rejected by the German basic law. In comparison, the Union's Charter lacks an equivalent statement on the legal quality of its provisions. So if you look from this, from a historical constitutional standpoint in Germany, you immediately discover, might there be some elements of the old Weimar Constitution? In comparison, as I said, the Union's Charter lacks an equivalent statement on the legal quality of its provisions. On the contrary, a clear response to this question is made difficult to ascertain by the Charter's explicit distinction between rights and principles. This is Article 52, paragraph 2 and 5. This indicates that not all provisions of the Charter contain individual rights. You find it in the Charter on fundamental rights, but if you look a bit more closer, then you will find not all provisions of the Charter contain individual rights which can be invoked by an individual before courts, but are principles to be concretized by political actions, of the responsible institutions of the Union, and this is dependent upon their political discretion. In addition, to make things even more complicated, the Charter does not itself precisely classify its provisions according to this demarcation line. The Charter says there is a distinction, but the Charter does not say which provision is an individual right and which one is a principle. Moreover, third complication, there might be even an overlap of both categories in certain provisions, both subjective right and principle. Here, legal erudition, law professors, and the European Court of Justice are tasked with clarification. What is the situation in 2020, June 17th, which used to be a national holiday, by the way, in Germany. But I'm not going in this, it's now October 3rd. Several judicial clarifications have already occurred. The European Court of Justice has affirmed as individual rights the right to non-discrimination on grounds of age, religion, and belief, the right of workers to an annual period of paid leave, and the right to efficient judicial protection. Just to give you some examples, there are others. And already since decades, the subjective right character is settled case law for several of the basic transnational market access freedoms of the internal market law, which are, to make things again a bit more complicated, repeated by Article 15, paragraph 2 of the Charter. What is meant with that? Namely, every union citizen's freedom to seek employment, to work, to exercise the right of establishment, and to provide services in any member state. And this is a huge configuration, from Portugal to Finland, from Greece to Ireland. On the other side, the European Court of Justice has denied the character of a subjective right which individuals may invoke as such due to their wording, for example, for the requirement that the Union recognizes and respects the right of persons with disabilities to benefit from integration measures, or has denied for workers' right to information and consultation within the undertaking. The same reasoning applies, in my view, to the program provisions of Article 38, which states that, I quote, union policies shall ensure a high level of consumer protection. Now, this is dependent upon political action, isn't it? Or of Article 37, which requires that, I quote, a high level of environmental protection must be integrated into the policies of the union, unquote. Here it is very clear. It's very clear. Addressees are the institutions of the European Union. Now, a new, astounding, and very debated judicial development has recently appeared on the scene of the European Court of Justice jurisprudence. Namely, the possibility that not only public authorities, which are mentioned in Article 51, Union, member states, but also individuals, which are not mentioned in this provision on the scope of applicability of the Charter, might have to respect certain provisions of the Charter. This is anathematic to any classical understanding of fundamental rights as dealing with the relationship between public power and individuals, but not applying directly to private relations, which means different treatment between individuals is possible. If you have a preference decision to buy a good from one seller and not from the other, you could say, isn't that discriminating? In a way, yes. However, there is in principle no way for the application of fundamental rights in the classical understanding. Nevertheless, the European Court of Justice held And significantly, I say this very accentuated, in a labor law case on the right of workers to an annual period of paid leave. And I quote, with respect to the effect of Article 31, paragraph 2, this is paid leave, of the Charter, an employer who is an individual, Article 51 does not address the question whether those individuals may, where appropriate, be directly required to comply with certain provisions of the Charter and cannot accordingly be interpreted as meaning that it would systematically preclude such a possibility, unquote. Now, what is the court saying here? The court says, because individuals are not mentioned in Article 51, perhaps such fundamental rights can be applied in a private relationship between individuals. This is the message which you can read. In my view, such an extension of the direct applicability of a provision of the Charter to private relations is reasonable only in a uniquely equivalent essential situation to a relation between public authorities and individuals. Otherwise, it would be a huge encroachment into the freedoms of individuals, how they contract with each other. This specific situation, uniquely equivalent essential situation to a relation between public authorities and individuals, might occur in the dependency relationship in labor relations. You might remember that I said I accent labor relations. This is indeed a very specific private relationship. So far for the fourth criteria. Now, when I look to the faces which are looking to me, are you still ready to stomach the four other criteria? I look to the chair, and the chair is my colleague Ribeiro Santiago. So I go at least on with the fifth criteria. The legal question of federal primacy. In view of the legal question of federal primacy, and this is now the situation, we have different promiser on in a federation, central level, and in a state, conflicts evidently can occur. And in view of the legal question of federal primacy, again, the German basic law can serve as a federal standard against which to measure. I don't know how this is in the Brazilian constitution, but perhaps afterwards, after my elaborations, we can talk about it. It contains now the German Grundgesetz, the short provision, I say it in German first, some of you have a feeling for German, I presume. Bundesrecht bricht Landesrecht. What a strong sentence. Federal law shall take precedence over state law. This is a more diplomatic translation. The German word bricht means breaks. Breaks. Yeah. But federal law shall take precedence over state law. This is Article 31. This applies also to the relation between different rules on fundamental rights protection in the federation on the one side and individual states on the other side. In union law, conflicts concerning the scope and content of fundamental rights in relation to member states should be solved in principle according to the European Court of Justice jurisprudence on the primacy of the application of union law in cases of a conflict with deviating national law. There is a very basic case. It's Costainel. It was a case which came to the court in 1964 from Italy. This means giving primacy to the Charter and the general principles of union law over national laws. However, on this basis, a differentiation between measures of the Union and the member states seems to be necessary due to the specific character of the federal community law of the Union. Don't forget, The European Union is not a state in the classical sense of Georg Jelinek. As far as the compatibility of union measures, in particular the so-called secondary law, primary law are the treaties and secondary law are then regulations and directives, is concerned, regulations directive adopted by the Union on the basis of its competences, administrative measures based on antitrust law. As far as the compatibility of these measures, union measures, is concerned, the compatibility with the Charter, its primacy should be beyond any doubt. National standards must not play any autonomous role in this respect, due to the postulate of uniform application of union law in all member states. So a regulation or a directive of the union could not be successfully attacked on the basis of a specific national fundamental right. However, some of you might be aware there is a deviating conceptual view of the German Federal Constitutional Court. Its approach, the so-called Solange II decision, as affirmed in its Lisbon Treaty decision, has been suspended by the court in practice, I quote, as long as, quotation ends, in German it's Solange, as long as the absolutely necessary standard of protection is generally not guaranteed by union law. So what is said with this as long as decision of the court is that there is not a absolute primacy, but it's only a primacy as long as the absolutely necessary standard of protection is generally not guaranteed by union law. Besides the upheld claim of the Federal Constitutional Court to have the basic power to declare a measure of the union inapplicable in Germany is, in my view, not persuasive in the system of German constitutional law. Why? Due to the openness of the German national constitution towards European integration. This is Article 23, and the competence attributed to the European Court of Justice by the respective German consent acts to finally decide on the validity or voidness of a legal measure of the European Union. But this is another issue. Now, so far for union measures, and I said one has to differentiate when it comes to the legal question of federal primacy. In relation to national implementing measures, again, the differentiation is necessary. Here, and now it becomes very detailed, but I don't want to leave this open. Here, between measures which are completely determined by union law and those which are not completely determined by union law, hence giving a member state leeway in the choice of concrete actions. This is often the case in directive of the Union, which by their very legal nature, I quote, shall be binding as to the result to be achieved upon each member state to which it is addressed, but shall leave to the national authorities the choice of form and methods, unquote. In particular, directives on the approximation of legal standards of consumer protection. For example, the right of withdrawal in internet contracts often leave member states leeway for adopting more protective standards than union law. So we have two groups. In the first group, national measures completely determined by union law, the primacy of the standards of the Charter prevails. For Germany, this has been recently, in November 2019, confirmed by the First Synod of the Federal Constitutional Court. However, with the additional requirement that the respective right is sufficiently effectively protected by the union right that applies instead. Now, for those with a fine absolute legal pitch, this word respective right might signal the potential for a slight difference to the previous as long as jurisprudence of the Federal Constitutional Court, since it centers on the respective right rather than on the general level of protection of fundamental rights. So it looks perhaps a bit closer. One will see. We don't have any judgment after this judgment of November 2019. In the second group, you remember, the second group of national measures, those which are not completely determined by union law, directive, which leaves it open what a member state does to achieve the objective envisaged by a directive. In this second group, the federal character of union law, of the union and union law, commands a dual compatibility, meaning a national measure that is compatible with the Charter must also comply with the standards of national fundamental rights and vice versa. For example, a national provision on data retention which satisfies the requirements of the Charter right to the protection of personal data must also fulfill the standards of a national fundamental right to privacy. Certainly only if not completely determined by a directive. This is a presumption. Or in the case of the adoption of a more protective standard of consumer protection by a member state, it must be compatible not only with the Charter's freedom to conduct a business, but also with the respective national guarantee. For Germany, the Federal Constitutional Court, when being confronted with assessing a national measure which is not completely determined by union law, has recently, also in November 2019, forged a remarkable connection between the standards of the protection by the Charter on the one side, and by the national fundamental rights as embodied in the basic law. The court holds that domestic fundamental rights are the primary standard of review for the Constitutional Court, even in cases where EU fundamental rights would also be applicable. Why that? The Federal Constitutional Court bases this jurisprudence on two presumptions. First, on the presumption, and I quote, that EU law, where it affords member states leeway, freedom to design, is generally not aimed at uniformity in fundamental rights protection, unquote. Second presumption, that, quote, that the application of German fundamental rights simultaneously ensures the level of protection required under EU law, which in this scenario seeks to accommodate diversity, unquote. Once again, application of German fundamental rights simultaneously ensures the level of protection required under EU law. It's a presumption. And of course, if you have a presumption, you can come to argue the presumption is not valid, but at least it starts with a presumption. Consequently, the Federal Court, Constitutional Court, in order to avoid disparities, also holds in this judgment that the domestic fundamental rights must be must be interpreted in the light of the Charter. Now, this is very interesting. First, he says, well, there is a difference, but then domestic rights have to be interpreted in the light of the Charter. In the light, how the Federal Constitutional Court understands such a fundamental right. And moreover, Federal Constitutional Court leaves two exceptions. First, in cases in which EU law contains stricter fundamental rights requirements. Yes, certainly. And second, if the presumption of the adequate level of protection in national law can be rebutted. So far for this aspect. Now we have only left three aspects more. I look into the eyes of our chair. She is still smiling. She is just raising the thumbs. She is my leader in this transatlantic diagonal conference from the Northern Atlantic to the Southern Atlantic. So I go on. 6. The judicial enforceability of the rights of the Charter. A specific federal aspect is also inherent in the issue of judicial enforceability of the Union's fundamental rights. In the German legal system, you see, I always use the same method. I take the German basic law because I'm familiar with it as a yardstick for federal state, and then compare it to the European Union's federal community of law. Now, in the German legal system, any person alleging that one of his basic rights, it says his, I'm just quoting, we understand it as also her, basic rights has been infringed by public authority can file a constitutional complaint before the Federal Constitutional Court. In comparison with the German judicial protection of domestic basic rights, Union law does not offer an individual the direct procedural means to lodge at the European Court of Justice a constitutional complaint based on the assertion that one of his or her fundamental rights in Union law has been infringed by a public authority. Hence, also for judicial protection, we have to look a bit closer, and I think a distinction has to be drawn between measures of the Union and the member states. In relation to certain acts of the Union, an individual may institute the general proceedings of nullification against an act of the Union before the European Court of Justice on grounds of infringement of the treaties. Well, here I would include the Charter, yes, because it's primary law, or of any rule of law relating to their application. Okay, any rule of law, general principles. However, any individual can lodge such a proceeding of nullification against a Union Act. However, not against any act of the Union. Only under the restrictive conditions of the relevant provision, which requires an act addressed to that person, or which is of direct and individual concern to them. For those of you who are interested, this is Article 263, paragraph 4 of the Functioning Treaty. Otherwise, the complaint of an infringement of a charter right can only be treated by the European Court of Justice in indirect procedures, such as the so-called incident control in another procedure, or a preliminary reference procedure, which can be, or in certain cases has to be, initiated by the autonomous decision of a national court, but which cannot be triggered by an individual. So you see, this is a restricted scheme. If an individual feels that it is negatively affected by a Union Act. If on the other side, a national implementing measure is attacked with the allegation that it infringes a fundamental right granted by Union law, this can procedurally be asserted only before a national court. A decision on the interpretation of a relevant charter right can be adopted by the European Court of Justice in such a case only if the national court had referred this question, which it, not the individual, considers relevant for its decision in the pending case, for such a preliminary decision of the European Court of Justice. It can be asserted only before a national court, and then it's up to the national court to ponder on the question whether this claim of an individual is relevant at all for its decision. When it comes to the conclusion, it is not relevant, then it cannot refer the question to the European Court of Justice. And if it is a court of last instance, it must not. It must not refer the question to the Court of Justice if it considered it as irrelevant for its decision. Second possibility, an infringement procedure against a member state is brought to the European Court of Justice by whom? By the European Commission or another member state. You see, those are then very complicated procedural ways to bring a complaint that a national measure has violated a charter right to interpretation of the European Court of Justice. In Germany, recently, November 2019, the Federal Constitutional Court has opened the mentioned remedy of a constitutional complaint in cases, I quote, where EU fundamental rights take precedence over German fundamental rights, unquote, for allegations that an EU fundamental right has been infringed by a national authority. Opens up the Federal Constitutional Court this constitutional complaint, which was considered until November 2019 as heading only against national measures on the basis of national fundamental rights, opens it now up also for complaints about an infringement of a charter right. Why? The Federal Constitutional Court sees, and I quote, that under current EU law, there would be otherwise a gap, and you look at in the protection regarding the application of European Union fundamental rights by the ordinary courts, unquote, since, quote, individuals have no direct access to the Court of Justice of the European Union to assert a violation of EU fundamental rights in such cases, unquote. You remember, the preliminary reference procedure cannot be triggered by individuals. This is in the discretion of any national court. This jurisprudence has two consequences. First, the Federal Constitutional Court, and I quote, itself can directly review on the basis of EU fundamental rights the application of EU law by German authorities, where there is a presumption that we have a provision which is directly applicable. It is a subjective right. I talked about this before. And second, the Federal Constitutional Court, interesting enough, if it takes it on, is obliged to refer the questions of interpretation of EU fundamental rights to the European Court of Justice for a preliminary decision in the pending case. It's the postman. Here comes the individual complaint, Karlsruhe, that's the seat, the city in which we have the Federal Constitutional Court, complains about being infringed by a constitutional request, being infringed by an act of the Union. Here is the Federal Constitutional Court and says, yeah, you can come with this burden to us, looks at it, and says, well, this charter provision has to be interpreted, and then the Constitutional Court is obliged to refer the question to the court in Luxembourg. And the Federal Constitutional Court sees this obligation. It does not swerve away, tries to deviate, right? Sees this consequence is clearly seen by the Federal Constitutional Court and also recognized with the word said, and I quote the Federal Constitutional Court, the Court of Justice of the European Union has the final authority for interpreting EU law, which includes the fundamental rights of the Charter, unquote. So in these cases, the Federal Constitutional Court assumes the function and the role of the postman of a constitutional complaint based on the assertion that a fundamental right of union law has been encroached. One would wish the Second Senate of the Federal Constitutional Court would have honored this passage of the First Senate. Federal Constitutional Court has two senates equal on the same level. One would wish, allow me this sentence, the Second Senate of the Federal Constitutional Court would have honored this passage of the First Senate before handing down its most problematic judgment of May 5th of this year on the competences of the European Central Bank and the European Court of Justice itself. But this is another topic, not our topic. Seventh, we are approaching, if you are a horse, the stables. So we are already approaching the end of this discourse. Factual scope of legal conflicts and judicial control relevance. Concerning the factual scope of legal conflicts and judicial control relevance, the role of fundamental rights of union law in the federal community of law depends on the volume of potential conflicts with public measures and their control. Well, again here, we can make a differentiation between union measures and national measures. Concerning union measures, in comparison to the array of measures that are available to a state, several factors might lower the factual importance of fundamental rights. Why that? Well, this pertains in particular first to union legislation, where it does not take place in form of regulations. Regulations, by their legal natures, are directly applicable in all member states. It is the European statute. Union legislation does take place mostly in the form of directives, not regulations, but directives. I quoted this already. It leaves the substantive implementing measures to the discretion of member states. And there is also still another aspect in union law. It happens not only from time to time, but quite often, that the legal texts are formulated in the open spirit of what in France is called caractère diplomatique, a diplomatic character. So there is leeway for the member states. Moreover, third, in the administrative area, the union lacks physical enforcement power. So for example, if a fine is adapted against an enterprise and the enterprise doesn't want to pay, it just resists, doesn't pay, then the union does not have a bailiff and will then go to the enterprise and will sell everything that is worthwhile to be sold. But then it needs the public power of the state in which an enterprise has its seat. In addition, fourth, as already outlined, union law offers only a restricted direct complaint procedure against acts of the union on the judicial level. Therefore, it seems that serious friction areas of union measures with the Charter will most likely be confined to administrative acts. And here, of course, as a basis for the enforcement, first of all, adoption of fines in antitrust law or supervisory measures of the European Central Bank over banks. And will also be confined to regulations as well as to precisely detailed directives, such as, for example, just to give you one example, a directive 2413 on differentiated insurance premiums and benefits between men and women, or a directive on the retention of data, very detailed, where you don't see a difference between the formulation of a regulation and a directive, leaving not very much leeway for the member states to implement it. They just have to copy it. they get it in their own language and they just copy it. Otherwise, they might start an infringement procedure of the European Commission against the non-proper implementation. Hence, in the long run, conflicts may more often arise in regards to national implementing measures. And now I have good news for you. We have finally reached the beaches, the shores of the end of this lecture, because we are approaching the 8th aspect, potential for judicial references and political guidelines. Without prejudice to the foregoing considerations, the Charter offers an unlimited potential of arguments to be made by all public bodies in the federal community of law of the Union, including both Union institutions and national public agents. In particular, it has long been visible that many political initiatives of the Union reference articles of the Charter as actively implementing them. For example, the General Data Protection Regulation. Also, decisions of the Union's judiciary use references to the Charter in order, why? To additionally strengthen the authority of the reasoning of a judgment, even if it is not necessary. We have seen several cases in the last couple of years, in the last 3-4 years, where everything was finally decided by the court, and then as an annex, also there was a reference to a charter right. Not necessary, but just to fostering the authority. However, caution should be taken, in my view. The more fundamental rights are referenced in daily life situations, the more their authority is endangered of being watered down. In light of the experience with the jurisprudence of the Federal Constitutional Court, in particular, the possibility to file constitutional complaints against judgments of courts. It's a constitutional complaint against the judgment of an ordinary court, administrative court, private law court, criminal court, tax law, all that. In view of this, the experience, it is possible to transform any social conflict in an issue of fundamental rights. I mean, we are creative enough as law professionals to do that. For example, even the private law issue of validity of the surety of a housewife given to a bank for the debt of her husband was transformed into the issue of a restriction of the fundamental right of liberty without any new aspects which had not been yet treated by the federal civil code. Or the private law issue of a private soccer stadium ban of a hooligan was transformed into an issue of equality before the law. Such a development can transport regular legal arguments in a specific area of detailed law into the rather abstract realm of discussions on fundamental rights and generate rather general assessments without any additional substantive concrete substance. Moreover, such a development may constitutionally unduly restrict the discretion, and this is now a very critical point. Such a development may constitutionally unduly restrict the discretion of the democratically elected simple majority legislator. At least in Germany, if something is protected by the constitution, then you need a 2/3 majority to change it. Here a problem arises. One has to be aware of this. On the other side, the fundamental rights argument provides an opportunity for strengthening the dominance of unbiased rationality, like in the mentioned insurance premium decision of the European Court of Justice. And this leads in its core to the general issue of the proper mutual balance between political authorities and the judiciary. Summing it all up, the federal comparison demonstrates a specifically distinctive and differentiated picture of the role of fundamental rights in the federal community of law of the European Union. It cannot be as comprehensive as in the Federal Republic of Germany due to the restricted scope of its applicability, but it can sharpen the argumentative equipment of all public authorities. Also, the Charter has not established a completely new dimension of the judiciary practice in Union law. It has codified the jurisprudence of the European Court of Justice, has developed since half a century, and has broadly enlarged the realm of fundamental rights protection in the European Union's federal community of law. Thank you for your attention. Obrigado.
Thank you, Professor, for your lecture. You are brilliant. It's a pleasure to hear you. Now, I would like to hear my coordinator, Jonathan Vita, about your historical lecture. Please, Jonathan, give us some words.
Hello, everyone. As Mariana stated, my name is Jonathan Barros Vita. I'm the director of the PhD and the master's program. And it's a really great pleasure to receive here Professor Muller-Graff at Unimar. And actually, I've been to Germany many times. However, I didn't attend any lecture in the University of Heidelberg. I've been
Next time.
Yes. Actually, I've been to Hamburg, Munich, all to events. Also, we have visited Professor Heberle directly. We've been to Gießen. Yeah. But in any case, I'm really an enthusiast about learning more about the fundamental freedoms, since actually my background, I have to say, is more on tax law. And the fundamental freedoms are the whole basis of the cases relating to tax law. And I was really wondering if you could comment a bit on the fundamental freedoms, especially in the pandemic times, because I think the interpretation of the fundamental freedoms relating to human law, to human rights will be really evolving and changing. For example, the residence of people will be changing because some people that were working in the borders of member countries will be affected, for example. We have many problems with abuse within the European Union, for example, the abuse of, and we have here a former director of one of the Brazilian clubs, Professor Rogério Mulica. And actually, it's very interesting because one of the most interesting cases on labor law is the Bosman case of the European Court of Justice. And also we have many cases of treaty abuse and voided state aid, such as Apple case, for example, that was ruled just a few months ago by the European Court of Justice, relating to state aid and the fundamental freedoms of the countries in attracting capital and the free movement of capital. So I think there are two main points here for you to comment, and I think it will be very interesting to hear those changes in the interpretation of the fundamental freedoms in the pandemic times, and also the problems of abuse within the European Union of the fundamental freedoms. And I believe this will suffice my curiosity, and it's really a great lecture, and I'm to be surrounded here also by Professor Mariana, who invited me to be alongside her on this event, and also Professor Rogério Mulica, Professor Marcelo Figueiredo, which is a prominent professor here in Brazil, and also Fernanda Serva, my vice rector, and Sinara Serva. Thank you very much, Professor Muller-Graff, and I hope everything is well.
Well, thank you very much for this comment. You have mentioned very different areas of law, very different cases. if I try to sort it, then there is one part, protection of fundamental rights in our pandemic times, and the other one, abuse of fundamental freedoms. But you mean with fundamental freedoms here in particular the transnational market access freedoms.
Yeah.
And I think one has to differentiate this a bit, but I will address both points. The first point, measures taken by public authorities now in these pandemic times. First of all, the European Union has only very weak competences in health protection, in a health protection in a operative way, let's say in this way, as there is one article on health protection in the Treaty on the Functioning of the European Union, but this has to do mainly with encouraging, coordinating, fostering the health policy of the member states, but not in the sense that the Union itself will adopt cogent measures, as those were your examples, as we are all faced with in the moment. Here, it is state law which is applicable. And of course, state law has then to conform with directly applicable union law. Here, of course, we have those cases. Suddenly, we see frontier controls or workers which can not come across the border, let's say from France to Germany, in order to work there because of a national measure that they can not come in without an important reason and without perhaps being put for some days in a quarantine. Of course, the national measures have to comply with the directly applicable provisions of European Union law. There have been other cases like the restriction of exports of some sanitary equipment. We are immediately in the free movement of goods, and we know, this is Article 35, namely the prohibition of quantitative restrictions or measures having equivalent effect. And if now suddenly some drugs or some masks or other sanitary equipment cannot be exported, then of course we have a problem with that. But we have also justifying reasons in Article 36. So here the European Union comes in a bit controlling. There are different, there are several areas which have to be considered. However, the main bulk of measures taken for the daily conduct and daily life in Germany, the bulk of these measures was not taken by the Federation, but by the single states. It's a federal republic composed of 16 states, and all these rules which were adopted were regulations of the states, not of the Federation, interesting enough. And the European Union is in a way far away. Here we have the states. They have also the physical power to enforce it, because the police is mainly state power. We have also federal police, which you see on the railway stations or which you see on airports. But basically, police in Germany is a competence and a matter of the states. And if something has to be enforced, it's always the state, it's not the federation. Just in this example, you can see there are the states which are at the front line. Of course, they came together in Berlin to discuss which measures should be taken and to harmonize this in the first weeks. Now, in June, mid-June, we can see very different rules in the different 16 states. And the federation, there are some rules also in federal law, but when it comes to the really working and enforceable acts, the states are at the front line, and the union is far away. Is far away. It looks only whether the rejection of a citizen of the union of another member state who wants to enter another state and is barred, if this is justified, if it is proportional, all that. Okay, so far for the first part. If there are open questions, we can come back to that. The second one is the aspect of the abuse of fundamental freedoms. And as I said already, this is a very specific part of subjective rights guaranteed by primary law. When I say primary law, this means in treaty law, and this means they can be changed only if all 27 member states of the European Union agree to change it. So you can imagine that this is a very strong fortress against amendments. We are talking, when we are talking about these subjective rights in the sense of fundamental market access freedoms to another country, then we are talking about free movement of goods. We are talking about free movement of workers, free movement of self-employed people, free movement of corporations, free movement of services, free movement of capital and payments. This is the realm of these basic market freedoms, as we call them. And here, what you mentioned, the cases showed up. Is there an abuse or is there not an abuse? And interesting enough, you said that you are a specialist in tax law, in particular in tax law. Here, these cases happen. Let's say in general, the European Court of Justice is very reluctant to say that something is an abuse of transnational market access freedom.
Especially Ireland.
Yes, for example. The European Court of Justice is very reluctant because it says, well, we are one common economic area, it's the internal market, and if somebody uses the better conditions in another country, this is the whole idea of being an integrated economy. However, when it comes to public revenues, to state income, there is a more closer look whether there is a model which is only used to evade the taxation in a state to which a corporation has a very close link and to get in Ireland, but it's not only Ireland, it's also Luxembourg, to get a better deal. So it's interesting that this question comes from you, being a specialist in tax law, because in tax law, indeed, there are might be loopholes, and here we see the Court of Justice to look more critical to creative ideas. Yo,
okay,
so far,
thank you. Thank you, Professor. Now I would like to hear Professor Marcelo Figueiredo about his considerations.
I can't hear you.
We can hear you, Professor. We have to.
But I cannot hear Marcelo Figueiredo.
Thank you. Hello.
Yes, I hear you.
Yeah, thank you. Well, good afternoon for everybody here in Brazil. It's a great pleasure to be here. Initially, I would like to thank you and the organizers for this important meeting, especially for the kind invitation that gives me the opportunity to dialogue with eminent colleagues as our rector, Fernanda Serva, my dear friend Mariana Ribeiro Santiago, to whom I thank you the invitation to be here, my colleague Rogério Molica and Dr. Jonahan Bila. I would like to greet our distinguished guest, Professor Peter Muller-Graff. He has just given us a magnificent talk about the fundamental rights in the EU federal community law. I believe that my role as a moderator is to bring to the meeting a little of our Latin America reality, or as some people want, the Ibero-American reality. It's quite the same. In any case, I see no point in questioning Professor Graff and his conclusions. And I'm very happy that he just made the lecture, because if I have to be in his place, it will be very difficult for me, because it's a very hard point of this conference. Fortunately, we didn't advance and we didn't arrive of this complexity of integration in Latin America. So what I did is I make a little draft of 5 pages for 10 minutes notes to bring to you and to everybody what's the état of art or state of art of this point of integration in our region. It basically is that. Initially, it's important to remember that in Latin America, we do not, and perhaps will never, have a federation of states or such a sophisticated type of integration as the European Union and its institutions. The regional integration in Latin America is a long but not successful story. Only by 1990, the creation of the new regional bloc, namely Mercosur, and the relaunching of 2 previous attempts, the Andean Community of Nations and the Central American Common Market, allowed to envision a different trend. Today, these 3 referred blocks feature a series of divergent characteristics, among them the reached level of integration and the type of institutionalization. However, all 3 have something in common. None fits easily in the theories of regional integration that were developed drawing on the European case. So what I will try to say quickly in rapid words, it's how this integration experience is working or it's not working now in our region. Well, my first conclusion, if I can arrive so easily to a conclusion, is that among the main findings is the increasing relevance of national executives as crucial driving forces of the integration process. This is not news, really a new news in Latin America. As we know, we have presidents and superpower presidentialism in our regions. My first note, it's about the evolution of fundamental rights in Latin America. Just to say that after dictatorship, 20 years of dictatorships, military or civil dictatorships in Latin America, we arrived to a new wave of constitutionalism with new constitutions. First was the Brazilian one in 1988, and then a lot of other constitutions, for example, Guatemala, Chile, Argentina, Mexico, etc., Paraguay, Peru. Well, to the end of the 80s, to the middle of the 90s, we have all new constitutions in Latin America. And all these new constitutions brought a lot of new individual and social rights and political rights. So in this point, we have, let's say, a quite new Bill of Rights in our constitutions. In a way, Brazilian's constitution and Article 5 with 78 incisions, we have a lot of very generous individual, social, political, cultural, and social rights. It's considered a very comprehensive Bill of Rights in our Constitution. What Brazil did in the 80s, in the end of the 80s, and all the other countries in a way did inspire in German culture, and it's Portugal, Spain, and the Constitution of German, many European constitutions. Let's say that for those points, we have a quite good Bill of Rights on the constitutions. And all the constitutions have also some specific provisions concerning the integration in our region. Cultural integration, common market integration, let's say, despite of two basic languages, Portuguese and Spanish. Of course, we are the only country in the South that speaks Portuguese. Everybody else speaks Spanish. Anyway, but so we can say that in our region, the incorporation of the universal and regional human rights treaties, such as the American Convention on Human Rights and its respective protocols, especially the San Salvador Protocol, allowing the economic, social, and cultural rights, should also be highlighted. So we can say that the vigorous evolution is gradually being observed in relation to the primacy, partial or total, of international human rights law in our region, as a movement that begins with Guatemala Constitution in 1985 and goes through Peru, Chile, Colombia, Brazil, and so on. So today, as you have the European Court of Law, Human Rights Law, we have here the Inter-American Court of Human Rights, who has been a protagonist, as we know, bringing the grammar of human rights and their interpretation to our entire region, with an important creative jurisprudence to change the less respectful standards towards the maximum effectiveness of fundamental rights through Latin America. My second point is the constitutional interpretation in the process of democratization in Latin America. And so we also learn from the Europe standards, the doctrine, etc., and also from the American constitutionalism, that it's very important study and develop the constitutional interpretation as a different or a special interpretation from comparative to the other kinds of interpretation of civil law, etc., etc. Anyway, so I'm speaking about Latin America, constitutional courts, etc. We increase the value of constitutional interpretation, as you did in German, and we learned from you and also from the American people, etc., from doctrine, also with many interchange from the German professors in Brazil and vice versa. Brazilians, federal judges and Supreme Court judges coming to German, to Spain, to Italy, and developing all this theory. So today it's a fact that we have strengthening the holder of constitutional jurisdiction with many names, different names, no matter now if we were a constitutional room or constitutional court as a European model, etc., etc. Anyway, so, and the third point that I like to highlight is that the human rights in our region, it's basically stated not only by our Supreme and Constitutional Courts, but also, as I referred earlier, for the inter-American system. We have this very huge development from the treaties of human rights in our region. And why this is so important? Because we, as we know, we have a lot of problems with impunity, defects and inefficiency in administration of justice, prolonged and illegal arrests of people, defects and difficulties in exerting the right to political participation, some countries more than others, weak institutions, high levels of common and organized crime, violence against women, systemic corruption, etc., etc. Anyway, so of course, in this scenario, it's very important not only have constitutions with fundamental rights, with a very good standards in our national constitutions, but also in the treaties that all the most of our countries sign up, and we can be guilty, as many countries of Brazil, Chile, and many others have been condemned by the court because our standards was not the inter-American standards of human rights. So, I should say that both the inter-American system and the European system of human rights protection are more or less immediate consequences of integration process in these respective regions. So, for my conclusions, I also remember that the broad application of the doctrine of conventionality control made explicit by the Inter-American Court of Human Rights and accepted by most of our courts or Supreme Courts of the region is hardly discussed anymore. Thus, the states of the region that are part of the Inter-American system must fully respect, comply with, and be bound to the court decisions and jurisprudence with is already an advance in the application of international human rights law. This is basically the scenario I would like to show our main guest so that he knows more and better our region. Thank you very much for your attention and patience.
Thank you, Professor Marcelo, for your considerations. Unfortunately, we are completely out of time. We have another event after that. So I think, Professor Muller-Graff, you will have to return to a complementary lecture in another day. I would like to ask you to say some final words to my students, because unfortunately we have to end it.
Well, let me say that your invitation was very inspiring, because sitting here on the other side of the Atlantic and on the northern hemisphere, I was suddenly dragged into imagining how I could present in a transatlantic diagonal way the situation of fundamental rights protection in this European Federal Community of Law. Perhaps I should add one aspect I haven't stressed. I was always talking about the European Court of Justice in Luxembourg, the Court of the European Union, because here we have supranational law. There is another court in Strasbourg, the European Court of Human Rights. And this court works on the basis of the classical international law. It's not supranational law, but has gained great authority, no doubt about it. Why am I referring to this? Because my estimated colleague, Figueiredo, has referred to the American Court on Human Rights. And it might be, if I'm not mistaken, that this American Court on Human Rights resembles more the European Court on European Rights, more the court in Strasbourg than the Union's Court in Luxembourg. And here we have, by the way, still another dimension, namely the relationship between these two European courts. This is until today an unresolved question, because we have the empowerment of the Union to exceed the European Convention on Human Rights, with the consequence, then of course, in a way, there would be a sort of binding authority of the European Court on Human Rights in Strasbourg. But the first effort to implement this provision, which is new, which came into the treaty in 2009, this failed because the European Court of Justice found that there could be some encroaching on its own authority. But I should mention that we have a second European court, and it's the court which has explicitly the name on human rights, but is not a supranational court. And now, perhaps this question might be still in time, my dear chair.
Professor, actually, the other event might start in 2 minutes now.
Oh, okay.
So really, we have to close this session down to open the second one. I'm really sorry about that. I'm really sorry, Professor Molika, who didn't have the chance to speak, but we have to make a second time in order to address everything to our students. And it was really a great experience, for sure.
But I thank you very much for the invitation. Obrigado.
Thank you, Professor. See you